Hello. Welcome to the James Patterson McBaine Honors Moot Court Competition. Thank you so much for attending. My name is Bill Fernholz. I am the Director of Appellate Programs at Boalt Hall. I'm so glad that you're here today for this extraordinary event. Look, I've got to tell you 3 things not to do. And then, because there are people in the audience who are not yet lawyers, I'm going to explain a little bit about what you're seeing, okay? So here are the 3 things that you should do. First of all, most of you, perhaps all of you, have one of these, right? You should turn it off. Because if the ringer goes off while these proceedings are going on, about 1,500 people will notice you and remember you, including some very prestigious people, okay? The second thing is no photographs. This is, first of all, we want the competitors to be completely focused on what's going on. Second of all, the panel has asked us not to have photographs. Now, there are some journalists here who will be taking photographs, but they are working under very severe constraints, okay? So they're not getting a real free ride here, okay? The third thing is that you need to be quiet during the final round. So what we're going to try now is just a moment of silence, okay? Oh, that was awesome. That was really good. So if you can just do that for an hour, I'll be so proud of you. Okay. So let me talk about what you're going to see. Look, what you're going to see here is an oral argument before an imaginary Supreme Court with a real US Supreme Court justice. A real California Supreme Court justice and a really extraordinary Ninth Circuit judge and also professor here. So when the judges come on stage, you're going to hear the words "all rise," and you're going to stand up. And then they're going to sit down, and then you're going to hear the words "you may be seated," and then you sit down, and then you have your moment of silence for an hour, okay? There is going to be, the first person who is going to argue is arguing on behalf of Donna Bush. They will take 25 minutes. Then the person arguing on behalf of the school district is going to take 30 minutes, and then Donna Bush is going to have 5 minutes worth of rebuttal, okay? If you don't know what this case is about yet, read your brochure that you got at the front, and it tells you what's happening in this case, okay? So for those of you who are not lawyers yet, what you're going to see is really a conversation, okay? But it's not an ordinary conversation because the judges are going to be asking the hardest, most difficult questions they possibly can in an evenly balanced case. And as a result of that, there are no good answers. There are only like second worst answers that people can give, okay? And that's where the skill and the tension comes out, and what makes this such an extraordinarily, almost theatrical event is that they're up against 3 of the greatest legal minds, and they have to react and keep calm and keep confident, okay? So if you, I know there are mock trial high school students in this audience. Here, all right, yeah. So this is the way to think of it. It's as if you were called into the principal's office, right? But there are 3 principals, and you have to stay out of trouble, and you have to talk to the 3 principals for an hour, and you cannot lie. That's what oral argument is about. So now, I want to bring out our principal, the dean of our law school, Christopher Edley, who will introduce the justices.
Welcome to the best law school in the solar system for present purposes. May I see the hands of anybody who's in high school? Okay. All right, listen, you are all guaranteed admission to Boalt Hall. All right? Just give me a piece of paper with your, in an envelope, credit card from one of your parents. I am extraordinarily proud this evening, certainly of Bill Fernholz and the team that's put together this competition and our advocacy program generally. Congratulations, Bill and team. But I'm especially proud of our two finalists. The work, if you've had a chance to read the briefs, is just fabulous. And had they not attended Boalt, they would have been nothing. Nothing, absolutely nothing. Bill did not say quite enough, but I won't belabor it, quite enough about how terrific this panel is. These are three extraordinary judges. And we're very fortunate that they've taken the time to render this educational service for our community. The only other thing I have to say is that I hope all of you will find some inspiration in this evening, some inspiration as to what the law is about, but also some inspiration as to what fine lawyering is about. It is certainly a profession, but it is a noble calling. At the end of the commencement ceremony each year, I remind our graduating students that when you finish law school and you take the bar exam and you pass the bar exam and you're admitted to the practice of law, you swear an oath. And that's not true for most degrees. But for this one, you swear an oath. So I hope what you will get a sense of tonight is the seriousness of purpose and the difficulty of searching for what is right when it comes to the most important challenges facing our society. And that's what we're about. So to get these proceedings started, I would like to call in the clerk for these evening's proceedings, Joe Rose, who is one of the organizers, one of the directors of the McBaine competition. So the clerk of the court, Joe Rose.
All rise. The Honorable Chief Justice and Associate Justices of the United States of America. Oyez, oyez, oyez. All persons having business before this honorable court are admonished to draw nigh and give their attention, for court is now sitting. God save the United States and this honorable court. You may be seated.
Petitioner's counsel, are you ready?
Good evening, Madam Chief Justice, and may it please the court. My name is Edward Piper, and I represent the petitioner in this action, Donna K. Bush. Before I begin, I'd like to reserve 5 minutes for rebuttal.
You may. Please proceed.
It is axiomatic that the government may not regulate speech based on its substantive content or the message it conveys.
Regardless of the forum and the audience involved?
That's right, Your Honor. The court has held in Good News Club, in Lamb's Chapel, and in Rosenberger, three of the cases that are most closely related to the issue here because they involve viewpoint discrimination, that restrictions on speech must be viewpoint neutral.
But didn't Hazelwood say that that kind of analysis that we applied in those cases had to do with the use of a forum, but that the review of issues relating to a curriculum were different?
It did say that, Your Honor, but it didn't fully explain that difference insofar as whether or not it goes toward or whether it allows viewpoint discrimination. I guess I'll begin then by talking briefly about Hazelwood, because respondents do rely heavily on it in suggesting, contrary to Tinker, that at least for the purposes of viewpoint discrimination, students and their parents, in this case Ms. Bush and Wesley, forfeit their First Amendment right to be free from viewpoint discrimination when they enter the walls of the school. Hazelwood did not address that issue, though. It's important to remember the facts that were before the court when it rendered that opinion, which did not involve viewpoint discrimination.
So you're suggesting that Hazelwood deals only with the notion of content discrimination and does not go all the way to viewpoint discrimination?
That's right, Your Honor. The court's opinion in Hazelwood actually did not discuss viewpoint discrimination because the restrictions that were put in place there were based on subject matter. Some of the newspaper articles that were excised dealt with sexual material, which the school felt might not be appropriate for some younger audiences. And also there were privacy concerns. Some of the people that were mentioned in the articles, it was felt that their anonymity wasn't adequately protected.
Your adversary points out in their brief that in fact there were 2 articles that were censored in Hazelwood, one of them dealing with teenage pregnancy, and that there were 2 other articles that were not censored on the basis of their content. So why isn't that, as respondents argue in their brief, actually a viewpoint case rather than a content case?
It's not a viewpoint case, Your Honor, because that isn't the reason that was given for censoring them. And I believe that information comes from the district court's opinion. The Supreme Court, this court, in rendering its opinion, didn't give any indication that had those privacy concerns been dealt with and had the subject matter been addressed as well, had the paper been addressed only, say, to the older students in the school, that the school then would have had any further objections to the newspaper articles, viewpoint-based or otherwise.
Could you tell me, for you, since Hazelwood seemed to be saying very directly that there's something different about curriculum control from control of speech in any other setting. You agree that Hazelwood does make that point?
That there is a difference between curricular speech and other
curriculum-related speech and other speech involving students?
Generally, yes. Hazelwood does draw that distinction.
Right. And the circuit court in this case, in one of its footnotes, footnote 29 at page 21, seems to suggest that your position is that once a school permits speech to students as part of their curriculum, that the school under no circumstance can engage in viewpoint discrimination. Is that your position?
That once they permit speech, that they may not then engage
on a particular subject, that they can't permissibly and constitutionally exercise viewpoint control. Is that, did the circuit court and describe your position accurately?
Not as a blanket rule, Your Honor. And that, I think, is where the Morse case comes in. That's certainly true as a general matter. But what Morse recognized is that there are certain extraordinary situations. In that case, it dealt with drugs and alcohol, where in some cases viewpoint discrimination may be acceptable. It's unclear from the opinion whether or not it was authorizing viewpoint discrimination. But the opinion itself was grounded in the pervasiveness of the drug problem. There were studies and statistics cited showing how drugs and alcohol, in this case it was marijuana that was at issue, are a really serious problem for educators. It would be a bit of an understatement to say then that religion is not the same thing. Religion doesn't present those same sort of pervasive risks. So this is not one of those extraordinary situations.
Can I ask you this? What if the case had been a little different? The case as we have it is that the teacher has a unit in which the kindergartners are said, this week you can present something, quote, all about me. They get to do a poster, and then one of their parents comes in and helps them read a favorite book or whatever. What if in setting up the What About Me unit, the teacher had said, I would like you to stay away from any serious talk about religion. You can say if you go to church, but I don't want any reading from any religious texts. Would that have been permissible in your view?
It would not have, Your Honor.
Because?
The courts in Rosenberger, Good News Club, and Lamb's Chapel faced similar issues and determined that enshrining that sort of, or giving that sort of instruction is essentially to enshrine viewpoint discrimination.
Why isn't that subject matter discrimination instead of viewpoint discrimination?
For two reasons, Your Honor. First of all, the particular forum that we're dealing with here solicited a class of viewpoints, namely what's important to you. The prompt asked the students and their parents to talk about their families and lives and hobbies and to talk about what's important to them. So that in and of itself is a viewpoint. But the court in Rosenberger also recognized that religion as a general matter, to approach a particular subject matter from a religious perspective, is itself a viewpoint.
Does it make a difference, or should it make a difference to us, that the cases you're talking about are almost all university cases or at the youngest high school cases, and we're here dealing with kindergartners?
The court certainly has recognized that distinction, Your Honor. And with regard to Rosenberger in particular, it was the University of Virginia that was at issue. But in Good News Club, the situation gets a little more complicated. It was, I believe, an elementary school in that case. The operative fact, though, being that the speakers that wanted to use the school were a children's club. The speakers wanted to come in and have a children's club and discuss teamwork and other sorts of values like that from a religious perspective. And the children were between the ages of 6 and 12.
And they voluntarily attended that club.
That's right, Your Honor. It's relevant, though, because
This was not a classroom setting. This was a club using a facility.
That's correct, Your Honor. They weren't in the traditional sort of curricular setting that we might find in a situation like Hazelwood. But it is instructive, at the very least, on the issue that Hazelwood makes as to whether or not there would be confusion, a misconception that the speech given in that setting would be attributed to the school. So the court has dealt with cases involving younger children in Good News Club, for example. They come up.
Counsel, following up on Justice Fletcher's hypothetical question, it seems to me that if a school opens up to parents or to children the opportunity to talk on a subject, animals, their love for animals and what they do with their animals, and a child or a parent proposes to get up and talk about how this particular child likes to torture animals, to kill them slowly and hear them squeal. Are you seriously suggesting that a school is without constitutional power to say that that type of discussion, that viewpoint, is one that is not appropriate for children?
I'm sorry, Your Honor.
Yes.
We certainly wouldn't say that. To continue with that hypothetical, I'll respond to the concern in two ways. First, it's important to note that there are other ways, aside from viewpoint discrimination, that a school can regulate material like that. For example, in that hypothetical you've given, Your Honor, there's an animal subject matter, but there's also violence. And it's on the basis of that subject matter that the school might legitimately say, we haven't included a discussion of violence in the invitation we've given you to speak. Another example that deals with religion specifically might, for example, be communion wine. If a student had come in and in response to the prompt given here in the All About Me activity said, I like to go to church and drink communion wine, the school could do essentially the same thing. There would be overlapping subject matters there.
Why? Meaning, what makes an educational need relating to violence or drugs or to any topic that you will concede the school can control because of its educational values? 'Cause that's what you're really saying, isn't it? Why are you describing some of those needs as compelling enough to permit viewpoint censorship and others not? Aren't you asking the court to sort of interfere with what's educationally appropriate and value-wise and what's not?
No, Your Honor. It isn't viewpoint discrimination or a compelling interest for viewpoint discrimination that would be the basis of the regulation in the examples we've gone over. It would be subject matter-based regulation. And it wouldn't be the court that determines whether or not those regulations should be put in place. That, of course, consistent with this court's jurisprudence on school officials having latitude to implement those sorts of regulations, would be left up to the discretion of the schools. The key question, though, is whether they may go further, whether they may, apart from just subject matter discrimination, discriminate on the basis of viewpoint. I should point out that—
Does it make a difference to you that the viewpoint at issue here is religious? Would you be making the same form of argument if the child had come in and said, all about me? I'll take a variation on Chief Justice Sotomayor's question, and it talked about how it was very important in his family that hunting be allowed, and his father's a hunter, and bringing in pictures of animals that had been killed by his father, and the teacher said, we don't want to do that. Would you be making the same argument when hunting it is issue compared to with religion being at issue?
As to the particulars of this forum, as to whether or not that restriction would—
In terms of whether or not this is viewpoint discrimination and the state and the school may not engage in it.
It would depend not only on the school's policy, but on its practice in administering that forum. If hunting or guns or whatever the subject matter was defined to be was included within that forum, then the school could legitimately impose a subject matter-based restriction there. I mentioned practice, though, because—
Why is that different from a subject matter description, a restriction such as, I don't want any reading from religious texts?
It's different in two ways, Your Honor. First, it's different because we know it was on the basis of viewpoint that this restriction was implemented. In addition to the viewpoint, the school might have been concerned with the subject matter at that moment, although I'll mention that there were other religious subjects, other types of religious expression that the school allowed prior to the regulation here. If you turn to the record at page 55, I believe you can see, or excuse me, let me make sure I have the citation to the record correct there. It's on pages 53, excuse me, Your Honors. You can find an example of an earlier part of the All About Me activity, where Wesley and his mother prepared a poster that contained religious material. So it's on that basis the court need not necessarily sweep that broadly in its analysis. We know that this is a viewpoint-based restriction, in part because there was other religious material that was allowed, and also because the school principal admitted it when he was imposing the restriction. The record at page 50, that one is on page 55, Your Honors. It has Principal Cook saying, and I'll quote, that the specific religious point of view was the problem here. So there are certainly practical problems in distinguishing between subject matter discrimination and viewpoint discrimination. We certainly don't mean to say that. But first, we know that viewpoint discrimination is what's going on here. And secondly, when it comes to practical problems that educators must face in administering these sorts of decisions, allowing viewpoint discrimination would actually compound educators' confusion.
Let me ask you this. Do we need, in order to resolve this case,
I'm sorry, Your Honor?
in order to resolve this case, do we need to define what kind of forum this school is?
I'll say you don't have to, Your Honor. That's because even in the context of, say, a non-public forum, or even under Hazelwood, there's still a reasonableness requirement. Perry, Cornelius, and Lamb's Chapel specifically.
Well, there may be a reasonableness requirement even so, but are you arguing for a reasonableness standard, or are you arguing for strict scrutiny?
No, Your Honor, I should be very clear about that. We certainly don't mean to concede that a reasonableness standard should govern here. We think that respondents created a limited public forum in administering the All About Me.
All right, and in creating a limited public forum, isn't the school allowed to say, we are inviting people to come here and talk about something, but we want to be clear on what the forum is. We want you to talk about All About Me, but we want you to stay away from religious texts. Isn't that part of creating the limited public forum?
It is not, Your Honor, because that would be viewpoint discrimination. The restriction there would not be viewpoint neutral. If they said, we'll entertain all viewpoints except a religious viewpoint, they on the face of whatever policy they implemented, would be discriminating on the basis of a particular viewpoint or a particular class of viewpoints, which the Rosenberger Court noted was no less
I'm not
acceptable.
sure why that's viewpoint discrimination. They're not saying, don't talk about this particular part of the Bible, don't read this psalm because it's promoting something we don't like. They're just saying our forum is such so that this subject, religious literature, whether it's, as Respondent argued, from the Satanic Bible or from the Christian Bible, we don't want either. So how does that become viewpoint? It's not the content of what you say, it is the source from which a subject is being drawn.
It's a question that varies depending on the facts, Your Honor, and there certainly might be some practical issues in separating viewpoint from subject matter discrimination. The two ways I'll respond to that concern, though, are to note that here, respondents have admitted that it was viewpoint discrimination. They cited the specific religious point of view as the reason, the only reason for implementing the restriction. And whatever practical problems there might be in separating out those two forms of regulation, the approach respondents are proposing, which is to allow viewpoint discrimination of religious speech, would compound the confusion that educators face.
But if we begin with the notion that generally schools are not public forums and that educators have to take some sort of affirmative step to create a public forum, I'm still unclear why they can't limit the nature of the limited public forum they're creating by saying, not, we don't want to hear anything from a certain religious point of view, we just want to keep a conversation of religious texts, whatever source, out of this conversation. In other words, when we create this limited forum, here's how we're limiting it. Why isn't that okay?
It's not okay because, as the Rosenberger Court defined it, religion generally, not just a particular religious faith or a particular religious source. The Rosenberger opinion, I should say the court held in Rosenberger, that to approach another otherwise permissible subject matter in a forum from a religious perspective does constitute a viewpoint. The Rosenberger Court actually addressed the very issue you're dealing with here, Justice Corrigan. The idea being that whether it's just a Christian viewpoint or a Jewish viewpoint or a Muslim viewpoint, or all three viewpoints together, in addition to maybe other religious viewpoints that are being excluded, it is still viewpoint discrimination. The fact that there are multiple viewpoints being targeted does not change that.
Lurking in this case is an Establishment Clause question. The Establishment Clause tells us, at least in the abstract, that the school cannot endorse a particular religious point of view such that the students feel in some fashion coerced. And I'll just read to you a sentence from Judge Sirica's majority opinion on the Third Circuit. Parents, he writes, parents of public school kindergarten students may reasonably expect their children will not become captive audiences to an adult's reading of religious texts. Now, that's maybe not a strict holding that the Establishment Clause requires the principal to do this, but you can certainly sense that in the back of the principal's mind is he doesn't want to even come close to the line of endorsing through a school lesson a particular religious point of view. Why is that not permissible for the principal to do as part of the pedagogical role of the school for very young children?
If there is a risk of that speech bearing the imprimatur of the school, then it would be permissible. However, the record in this case just doesn't bear that out. It was called the All About Me activity. It wasn't the teacher that was actually speaking. It was a student's parents, and they were clearly identified as such.
You don't think that a child in a classroom believes that anyone who the teacher permits to talk, especially another adult, that the teacher is endorsing what that adult is doing, that the teacher is somehow affirming the topic and the substance of whatever that individual is presenting? Especially if you're a kindergarten student?
Hypothetically, Your Honor, it's possible that in some situation that might happen, but the record here does not make it clear, one way or the other. It's an intensely psychological, scientific question, whether kindergartners, even given the fact that it's identified as the All About Me activity, that the parents are identified as parents and not teachers, whether a kindergartner would still confuse that speech requires...
So who makes that judgment? We're judges. You're not. You're a lawyer. You're not a teacher. Didn't we in Hazelwood say that we have to give respect to the educators to know what is best for the students they're teaching? And so why don't we take this principle at his word that it would potentially confuse these children?
Hazelwood did not authorize that. It didn't address that question because it did not deal with viewpoint discrimination. It did not weigh the First Amendment violation, the First Amendment interest, I should say, that is very much at issue when dealing with viewpoint discrimination over school administrators' need to be able to make on-the-spot decisions.
But if the question is as close as you seem to acknowledge that it is, having all kinds of facets to it, pedagogical and psychological and many other logicals, are we in the position that we should step in and override the best judgment of someone who is much closer to the situation with a much different skill set than perhaps any of us in this conversation possess?
To the extent that it is viewpoint discrimination, yes, Your Honor. The practical concerns that educators do have to face, though, would be compounded by Respondent's approach. Rosenberger held that the First Amendment's the Establishment Clause's guarantee of neutrality is, in fact, undermined when educators single out particular types of religious speech, whether based on their religious character generally or on specific types of religion that are sought to be expressed. The problem, however, as Rosenberger noted, is essentially an unanswered question of how much is too much. If, as respondents are asking the court to hold, viewpoint discrimination is okay in some circumstances, Rosenberger would tell us that at a certain point that would lead to an Establishment Clause violation. Certainly if the school, as part of the All About Me activity, said we're going to entertain Christian viewpoints but not Muslim or Jewish viewpoints. I see I'm out of time. May I briefly finish, Your Honor?
Just that sentence.
Certainly the Establishment Clause would be implicated there. I thank the court very much for its time and urge it to reverse the ruling below.
Madam Chief Justice, and may it please the court, I'm Thomas Frampton for the respondents, the Marple Newtown School District, and educators at Culbertson Elementary School. The Constitution presents no bar to a kindergarten teacher restricting what's presented to a captive audience of 5-year-old children inside her classroom, provided there's a reasonable justification for so doing. That was the standard adopted by the Third Circuit, which respondents urged this court to affirm. There are really two issues at the crux of this case. The first is that when dealing with school speech that forms part of the curriculum or that might be perceived to bear the imprimatur of the school, it's this court's holding in Hazelwood that controls. And second, when dealing with this very narrow class of expressive activities at school, we defer to educators, and Hazelwood authorizes them to restrict the contents of such speech in any reasonable manner. That's what occurred here. Before I address
let me just push back a little bit. Can we agree we are talking about regulations that impinge on constitutional rights, right?
The assertion is that this violated the petitioner's First Amendment rights, if I understand your question, Justice Court.
Well, do you agree that this regulation impinges on the constitutional right under the First Amendment?
We do not agree. The regulation here was reasonable, and that was the standard that was established by Hazelwood.
I understand that, but customarily we don't simply say if we're talking about a right of constitutional dimension, an infringement just has to be reasonable. We ordinarily say that if the right is of constitutional dimension, before the government can start impinging upon it, it must withstand strict scrutiny. Isn't that the customary standard?
Justice Corrigan, it may be in those situations where the traditional forum analysis applies and we're talking about a strict viewpoint-based restriction on free expression. But there are several problems with that. The first is that we're dealing with a school here, and throughout the past 42 years of school speech jurisprudence, this court has remained consistent on one fundamental point, that the special characteristics of the school environment require us to apply the First Amendment differently in the school setting than we would in any other context, and that the forum analysis framework should not be imported into the classroom.
So you would suggest that we not only don't need to, but that we shouldn't try to analyze this in terms of public forum, limited public forum, non-public forum?
Justice Corrigan, in all 4 of the school speech cases that have come before this court since Tinker v. Des Moines, this court has not engaged in that sort of forum analysis. Instead, it has articulated 2 different standards that apply for school speech cases. One of them was established by Tinker and since elaborated in Fraser and Morse v. Frederick in 2007. That's the standard that applies where speech does not bear the imprimatur of the school. Even under that stricter standard, we believe that the restriction was permissible under the First Amendment. But this speech falls under a different standard that was announced by this court's holding in Hazelwood in 1988. When speech bears the imprimatur of the school or as curricular speech, Hazelwood authorizes them to restrict it in, quote, any reasonable manner. So that's the standard that governs for this case.
I'm just trying to get an answer on my threshold question. Are you taking the position that we should not analyze this case in terms of the nature of the forum, but instead to apply a different analysis?
Yes, Justice Corrigan.
All right. And the analysis we should apply because of the school nature of this is whether or not the government is lending its imprimatur through the allowance of this discussion in a public school to, in this case, a religious point of view. Is that right?
Somewhat. Justice Corrigan, the first step of the analysis is whether this is speech that might be perceived to bear the imprimatur of the school. Mm-hmm. If that is the case, then the second step of our analysis is to look at what Hazelwood authorizes. And and Hazelwood, our position is that it authorizes restrictions wherever reasonably related to a legitimate pedagogical concern.
Okay, so what is the legitimate pedagogical concern here?
I think there are at least 2 that are discernible. The first is the school has an interest in ensuring that the contents presented to students are appropriate for their age and their maturity level. That was conceded in the petitioner's brief.
Counsel, you talk about that on page 26 of your brief, and you argue that this text was just not within the understanding of children. I've searched the circuit court's opinion to find some reference to that as being the reason the school censored this speech. I couldn't find it. So what are you relying upon to raise that argument?
Madam Chief Justice, I'm relying on the statements of Jamie Riley, the kindergarten teacher in this case, and Thomas Cook, the principal at Culbertson Elementary School, who said that this would not be an appropriate reading for a kindergarten class with a captive audience of 5-year-olds.
I read the circuit court opinion, and it basically said the principal said it's illegal. You're mixing state and church. To whatever extent the word inappropriate was used, it wasn't inappropriate other than as an illegal act. So I don't know where those arguments that you're making relating to this issue of the capacity of the children to understand the reading was ever referenced by the principal or teacher.
Madam Chief Justice, I would point to page 55 in the record, the passage that was also cited by the petitioner. The principal's full sentence was not that it was the particular point of view of the petitioner that was objectionable, but the fact that she was promoting and proselytizing that point of view. I think that's where we get into the sorts of issues that were implicated in your question. Insofar as for a 5-year-old audience, a specific reading that says they should give thanks to the Lord, that they should say that the Lord's mercy endures, and exalting those who fear the Lord, crosses that border into area that it might not be appropriate for the age and maturity level. And to the extent that it is an open question, we should defer to educators rather than the federal courts.
Is it your position that it's absolute deference? The end of your brief, I seemed to think from all the arguments that you were raising that there really was no meaning that you were giving to unreasonable, that you were basically advocating absolute deference to the judgments of teachers as to what was appropriate for children. Is that your position?
No, it's not, Madam Chief Justice. The test that was established by Hazelwood was reasonably related to a legitimate pedagogical interest. The record in this case is unambiguous that the restriction was not related to animus in any way towards Christians or people of religious faith. I think a restriction on speech that were motivated purely by racial animus or religious animus or other forms of unconstitutional values could be vetoed by a court to say that that's not a legitimate pedagogical interest. It doesn't mean that we have to declare this entirely to the limits of educators, but where there are legitimate pedagogical interests at stake and where those restrictions are reasonably related.
So what is the interest here? What is the educational interest?
I think there's two.
Articulated as?
Well, one is the age and maturity of the students, but the other is to look at what this all about me exercise was for. It was an activity that was designed to, quote, help students identify differences with one another and to learn how to resolve those differences. To that end, it was important for the kindergarten teacher in this case to give Wesley the opportunity during All About Me Week to talk about his faith, to explain why going to church was important. She, in fact, displayed a board that said, I love to go to the house of the Lord. But they made a determination that telling students that they needed to fear the Lord or give thanks or say that the Lord is great didn't really serve that purpose of helping students resolve their differences.
You know, I have to say that you're right on the point that most bothers me about your side of the case. The teacher says this is an exercise in which each child is to come in and say things, quote, all about me. And in this child's case, the fact that he goes to church frequently and that his family is evangelical Christian is clearly something very much about him. Insofar as we may talk about a kindergartner as having some sort of central set of things about him, this seems to be very close to the center. And having set that up as the central criterion, all about me, for this lesson, that all of a sudden the teacher says, well, as soon as he talks about, or as soon as we have a reading from the central text, whoops, you can't do it. This is, to me, sounds like a very different case from if the exercise had been set up differently, even to the point of my earlier hypothetical. You can talk about religion, but we just don't want any religious texts. So it seems to me that the rules were changed here in midstream based upon an objection to this religion and this religion's text. How do you respond to that?
Justice Fletcher, I respond to it by making the point that this is the Bible might have special significance were this a free exercise case, or if this were an establishment clause case. But the theory advanced by the petitioner is that the Bible deserves special solicitude in this case insofar as it constitutes a viewpoint on the subject of Wesley. So it's important to remember that the respondents are willing to concede that might be a sort of viewpoint, but it would be no more or less a viewpoint than the Communist Manifesto, or a book denying the Holocaust, or the Satanic Bible, or a book that says God is not great. So in that sense, I think it's important to remember that in arguing on the axis of viewpoint versus subject matter, petitioner must take the bitter with the sweet. And if it's reasonable in certain instances to restrict what might be deemed inappropriate materials where reasonably related to a legitimate pedagogical purpose, then
Well,
that's okay.
I understand your point that this is not a free exercise claim. To the extent that there's a First Amendment religion claim, it probably is an establishment claim lurking somewhere in the background of this case. And the way we ordinarily see an establishment clause claim is that the school has somehow endorsed speech. In censoring the speech of the mother and telling the mother, you cannot read this religious text, it sounds as though the school is endorsing an anti-religious point of view. And in one sense, it's an establishment clause problem because of censoring the Christian Bible. How do we get around that?
Justice Fletcher, I think we get around it through the Lemon test, which is the test this court typically applies for establishment clause cases. This was a restriction that was made with a secular purpose. It was a restriction that did not have as its principal primary effect promoting or inhibiting a certain religion. And it didn't promote or lead to an excessive entanglement between the state and religion. So as the lower courts made clear, this didn't raise to the level of an establishment clause violation. But I think the point implied in your earlier questions, Justice Fletcher, are relevant for our purposes. There is some level of cognizable state interest in wanting to promote a secular education, in not wanting to come anywhere close to the borderlines between what constitutes an establishment clause violation and what doesn't establish.
Well, while you're on that very topic, doesn't the record reflect that at least twice a year the school allows Jewish parents to come in and talk to the students about Hanukkah and Passover?
Yes, Justice Corrigan.
Well, that's a little closer to the line of becoming involved with religion, isn't it?
Somewhat, Justice Corrigan, but this court addressed a similar issue in County of Allegheny versus ACLU of Greater Pittsburgh. That was a case involving a city hall that had both a nativity scene display as well as a menorah for Hanukkah. And the court ruled that the nativity scene constituted an establishment clause violation, but the menorah didn't. The court engaged in a similar analysis that the school officials did here. It said, we're all right to have cultural symbols or artifacts, but where it becomes religious, we're going to treat it somewhat differently.
And how exactly do we determine the very fine line between what constitutes a cultural approach to tradition and a religious approach to tradition? How do we articulate that distinction?
Justice Corrigan, I don't know that we have to answer that question to reach the right outcome here.
Well, as I understand your argument, you are saying that asking the Jewish parents to come in and talk about Passover and Hanukkah is cultural, not religious, but that here the parent speaking very relatively briefly and somewhat informally, as opposed to a regularized twice every year we're coming in to talk about this approach, is religious. And I'm trying to figure out how you're making that distinction.
Justice Corrigan, the distinction is that I believe your question with respect to the menorah or other Jewish symbols, and there was also for Christian holidays, cultural celebrations.
Well, actually, that's not what I'm talking about. I'm talking about what happened here, which is parents from two different religious traditions coming into the classroom and speaking about their religious traditions to these children. So as I understand your position, you're saying one is cultural and the other is religious, and I'm not clear on how you get there.
The decision and the way that we get there, Justice Corrigan, it relates to the bigger context of this. You're talking, I believe, in an establishment clause case of when the school would have to censor that speech. The question here isn't whether they had to censor the speech, but whether the First Amendment prohibited them from engaging in a certain restriction. If that were speech that bore the imprimatur of the school, whether it be a dreidel or a menorah, and if there was a reasonable pedagogical reason for restricting that sort of speech, the school officials would be perfectly within the bounds of the Freedom of Expression Clause to restrict that speech. That's the sort of problem we're facing.
But why do they have a valid educational reason for permitting it in one context and not in this one? I think part of Justice Corrigan's question is, so what's the difference? They're both religious. They're both viewpoint. One's talking about Passover and the importance of a particular holiday to a particular faith, and the other's reading from the Bible, which is a central, important symbol or source of that religion. So what's the difference?
There are several differences, Madam Chief Justice. One of them is that this is proselytizing. This was proselytizing speech that instructed a captive audience of 5-year-olds how to engage.
How do you define proselytizing? What is, and what's the definition of that?
Madam Chief Justice, I think that's a decision that we leave to school officials. And I think it's also
Well, that's
important.
fine, except that I have to judge whether their acts are reasonable. So you have to tell me what they mean by that word.
Your Honor, I don't think it matters what's going on inside of the petitioner's head when she stands in front of that class.
You really can't seriously be arguing, are you, that if she says, I didn't permit this because it was proselytizing, and I read it and say, as far as the dictionary definition of that word, it's not proselytizing, and I'm going to say it's unreasonable. If you give a reason that doesn't exist, how can it be reasonable?
Your Honor, the reasonable state interest that was involved in this restriction was that it didn't help students in the stated activity that the parent was invited there for, which was to help students resolve their differences with one another. Now, whether petitioner's goal in coming to that kindergarten classroom was to convert souls or proselytize or merely read a piece of poetry that she found to be particularly meaningful, the question for us is, what is that kindergarten teacher going to do with that speech, and whether she should be afforded, within a range of reasonableness, the discretion to say, you know what, I don't think that this is going to be appropriate for the students in our classroom. Now,
But I'm still waiting to hear why it's okay to come in and do a lesson plan on Hanukkah and Passover twice a year, and to have a book in the school library that says, hooray for Hanukkah, sounds a little proselytizing, maybe, and why this recitation that the parent very carefully selected, because it didn't make any direct reference to Jesus or Christianity or any of the other things that might get closer to the line. I'm still unclear on the distinction that you're making.
Justice Corrigan, I think I understand your question better now. I believe that what you're getting at, though, is whether we start to have an equal protection problem. The question, though, that this court granted cert on isn't whether it would be also permissible for the school officials to censor the religious speech from other faith traditions.
But because clearly they haven't done that.
Well, Your Honor, we haven't had religious proselytizing on behalf from the Satanic Bible or from the Quran or from other faith traditions. Presumably, and this is what the lower court said, that would also be censored in this case. The courts made clear that there was not a hint of religious animus. If there were religious animus, and if this were a restriction that were motivated because Wesley was a Christian, we would have an Establishment Clause problem, and we probably would have an equal protection problem. But that's not the case that's at bar today. The question that's at bar today...
How do we know there's no religious animus? Animus is sometimes descriptive of the state of mind of the person who's censoring, but it's also something that people can sense themselves, and so it's a very difficult concept sometimes. You may not have intended to insult me, but I feel insulted, and on reflection you may go back and say, you know, I guess I really did insult him, and maybe it was insensitive to me, and maybe if I really get down into my heart of hearts, I meant to insult him. This is a school that has a holiday tree. It does not have a Christmas tree. This is a school that allows and encourages descriptions of Hanukkah and so on, and then as soon as we get reading from the Bible by someone who's an evangelical Christian, but a carefully chosen reading from Psalms, we're not talking Luke or Mark, all of a sudden she's shut down and the little boy is shut down. How can I be so confident that there's no animus?
Justice Fletcher, I think the previous history of All About Me Week shows it. If there were animus here, Wesley would not have been allowed to say, hey, I'm an evangelical Christian, this is why it's important to me, this is what's important for my family, we regularly go to church. The fact that Petitioner's poster saying, I love to go to the house of the Lord, with a picture of a Christian church, was permitted to be displayed on the walls of the kindergarten classroom, shed light on the type of restriction that was at issue here. What we're dealing with here is a case that, if it is bearing the imprimatur of the school, the question becomes, what's the standard that should govern the restrictions? And a compelling state interest standard simply isn't workable within the context of an elementary school education. Again, because we're talking about this as a viewpoint, I think that the situation that the Second Circuit found in Peck v. Baldwinsville would be instructive, because that's a case that looks very similar to the one at Barr. In Peck v. Baldwinsville, a kindergarten classroom conducted a 2-month-long educational unit on environmentalism. And at the end of that unit, the teacher invited parents to come in and share their views about what students could do to save the earth, conserve resources, work to save the environment at home. And adopting the petitioner's reading of Hazelwood, the Second Circuit concluded the First Amendment required that teacher to publish a poster that said, prayer to Jesus Christ is the only way to stop global warming and to save the earth. The same reasoning would apply if that poster espoused a viewpoint that clean coal technology were the only way to save the earth. And I think this is the critical point. The Marple-Newton School District in Pennsylvania might want to talk about coal in the context of an elementary curriculum. Pennsylvania is a coal-producing state. But the Berkeley Unified School District might not. And within a range of reasonableness, we need to give that discretion to educators, to democratically elected school boards, and to educators who are actually in the classroom to decide what sort of materials they want to introduce, because we're dealing with a captive audience. The compelling state interest standard is that which governs the police chief who's overseeing a soapbox in a public park. Petitioner asked that the same standard be applied to a kindergarten teacher overseeing what happens in her kindergarten classroom. But those are two very different settings. In a public park, we think it's important for an individual, whether they're a member of the American Nazi Party or the American Communist Party, to be able to espouse their views, however disagreeable the community might find them.
Because that's a public forum, right?
Right. Justice Corrigan, when that same individual is a parent at Culbertson Elementary School and is invited into a classroom for a relatively innocuous exercise, she should not, and he should not, have the same right to espouse those views. That would be the consequence of adopting a compelling state interest standard.
And when the Jewish parent is invited in to explain Hanukkah and Passover?
Justice Corrigan, if there's a reasonable reason for that restriction and the speech bears the imprimatur of the school, and that restriction can be tied to a legitimate state interest, it would not offend the First Amendment's free expression clause.
So how does it bear the school's imprimatur when the children are told that this is about each child and their interest? So even kindergarten kids understand when they're told what an exercise is about. So how is the child going to believe, or why would the child believe, that it's the school endorsing this speech?
Madam Chief Justice, the school doesn't have to endorse the speech. It's important to recognize that the imprimatur does not require the school's endorsement or the school to affirmatively subscribe to the specific viewpoint espoused. An imprimatur, in the historical sense, was a seal that was affixed to books by the crown in the 17th century that said nothing heretical or seditious is contained within this book. It didn't mean that it was the king's speech. It meant merely that it had the general grant of approval. I think the answer to your question in this case is that we're dealing with 5-year-old children, captive audience, inside of a classroom where the teacher has previewed the speech and where the teacher would be standing alongside the parent when the parent spoke. That's the kind of thing that makes children and members of the public might reasonably perceive that speech as bearing the imprimatur of the school. And it's what distinguishes this case from a hypothetical English classroom. If an English teacher in a high school English class were to say, bring in a piece of poetry or persuasive writing that you find particularly compelling, it'd be much harder to make the argument that this very same piece of writing, Psalm 118, bore the imprimatur of the school in that context. But when we're dealing with a captive audience of 5-year-olds, I think it's exceedingly difficult to come to the conclusion that that's speech that wouldn't bear the school's imprimatur. Now, it's important to recognize that even if this were speech that weren't bearing the school's imprimatur, this court in 2007 sanctioned what it called unabashed viewpoint discrimination of school speech, even in the absence of a compelling state interest in Morse v. Frederick. And Morse v. Frederick was the Bong Hits for Jesus case, and that was a student who, off campus during a voluntary field trip, unfurled a banner that undoubtedly would have been protected speech had it not been occurring in the school. And what's relevant for us for this case is not that Morse v. Frederick is the standard that should govern, but that even by that far more demanding standard, this court, both in the majority opinion written by Chief Justice Roberts and in the dissenting opinion by Justice Stevens, made clear that this was a case of unabashed viewpoint discrimination. And there wasn't a compelling state interest involved, yet it was still permissible for the school to engage in that sort of restriction.
Well, Bong Hits for Jesus, I think the court was focusing on the bong part and not the Jesus part.
I am a little, I thought that they were focusing that as an important compelling state interest to combat the use of illegal drugs or the potential endorsement of illegal drugs.
With respect, no, Madam Chief Justice. At page 409 of the opinion of the court written by the Chief Justice, they in fact refrained from identifying a compelling state interest. And notably at 439 of the dissenting opinion by Justice Stevens, we see the same thing. The court didn't go into the compelling state interest standard because that's never been the approach that we've used for dealing with school speech cases. Of course, it would be if the petitioner's reading of Hazelwood is correct. The irony of the petitioner's reading of Hazelwood is that the school officials would be allowed to restrict that sort of speech when it occurs off campus during a field trip, unquestionably not bearing the imprimatur of the school. But the petitioner's reading of Hazelwood would prohibit them from doing just that in the context of a kindergarten classroom. That would invert the hierarchy that this court established in announcing Hazelwood in 1988 to give school officials greater discretion over a certain class of speech. There's other reasons, however, that we know that when Hazelwood says any form of content discrimination, that it necessarily includes all forms of content discrimination, including the viewpoint discrimination.
You know, you made a point in your brief that there's nothing in the jurisprudence of the Supreme Court that allows a forum analysis in an educational institution. So we're not even allowed to talk about this in the framework of limited public forum. Can we kind of hint at limited public forum? Because what bothers me about this case, again, is that it seems to me that the teacher opened up a certain subject, and this is well within the subject. And all of a sudden, as soon as it's religion and as soon as it is something that can reasonably be seen as a form of proselytizing, she shuts it down. This is not the case where she has said, we're going to eliminate religious texts, and all of a sudden it's more limited from the outset. No, she doesn't limit it until she gets the religious text, and then all of a sudden she limits it in a way that she'd not previously seen fit to do.
Justice Fletcher, I would not presume to tell the court what it could or couldn't discuss as far as the forum at stake in this case. The point, however, though, is that the petitioner's proposed ruling is, even if this is reasonably related to a legitimate pedagogical interest, as the lower courts found, even if that's all conceded, that's still not enough. That we still need a compelling state interest. That was the question that this court granted cert on, is that where we're dealing with this sort of speech, do we, within a range of reasonableness, permit the restriction, or do we say that we need to get something more? I think the irony, Justice Fletcher, of the case before the bar is that although the petitioner's argument is being advanced under the banner of promoting free expression at schools, in practical terms, it's going to have the exact opposite impact. If school officials at East Hazelwood High are told that if 1 week the Spectrum newspaper, they're going to publish an editorial that deals with racial integration or the impact of the Holocaust, viewpoint neutrality requires them the next week to publish a student editorial that promotes racial separation and denies the Holocaust, which would be the consequence of a viewpoint neutrality rule. There's a simple answer for them. They're going to stop having the newspaper. The National School Boards Association filed an amicus brief in this case that made the same point, that if under the guise of a relatively banal classroom exercise, kindergarten teachers are told that the First Amendment requires them to throw open their doors to any conceivable viewpoint that might be responsive to the restriction, they simply won't invite parents. And for that reason, we urge the court to affirm the Third Circuit's holding. Thank you.
Petitioner has 5 minutes.
Counsel, would you get to one question, and that is responding to your adversary's point. The amici have made this point, Respondent made it in their brief, that if we rule in your favor, we will be forcing schools not to open themselves to liability and to exclude discussions on topics because the school might fear information or a viewpoint that they would think harmful for children. So
I'll respond to that question in two ways, Your Honor. First, I'll note that there are other ways that schools might regulate those sorts of materials. As the court noted during the first part of my argument, schools are traditionally not public fora to begin with, and they're under no obligation to open curricular activities to the sort of broad expression that they did in the All About Me activity. Justice Fletcher, you noted that it was a very broad invitation. Moreover, if
could they have simply said, all about me except about religion?
That would be viewpoint discrimination, Your Honor. If they're concerned with some of
So
the
it's content. I don't care what religion or non-religion you're promoting. This is the topic, no religion.
And we're just limiting the nature of the forum. We're telling you what the limit on the forum is.
So if the court is to decide that that is the case, that schools may impose those sorts of broad-based limitations on forums, which I want to be clear, we don't mean to concede that that would be acceptable, but if the court determines it is, it would be subject matter, it would be a subject matter-based restriction that is not like the one we're dealing with here. The principal admitted it was the point of view, not just religion generally, but the specific point of view that was at issue.
So you would be willing to go so far as to say they can say no religion at all, but they can't say, well, not this religion.
No, Your Honor, I don't mean to concede that Rosenberger's holding that religion generally constitutes a viewpoint is wrong. But if the court determines it is, what we'd say is that that is still subject matter based, it's a subject matter based restriction that we're not dealing with here. Justice Fletcher, you also noted earlier that earlier in the All About Me activity and in a very closely related activity, the school actually had allowed religious expression. It had allowed the presentation on Hanukkah by a parent, and earlier in the All About Me activity, it had allowed the poster with the picture of the church and the words, "I love to go to the house of the Lord." In that sense, it's actually respondents that must take the bitter with the sweet. Justice Fletcher, you noted that they must play by the rules that they themselves set, and that's what they haven't done here. So with regard to that concern, the court need not sweep so broadly in determining whether or not those broad-based restrictions on religion generally are subject matter or whether they're viewpoint, because we know in any event that that subject matter was permitted here. Now, in the time I have left, I'd like to briefly pick up where I left off. I think the entire court touched on the difficulty in distinguishing between cultural speech and religious speech. That's a very difficult line to draw, particularly as a school administrator that has to make on-the-spot decisions. Counsel mentioned a possible chilling effect on student speech. That could still happen with respondents' approach. They wouldn't be worried about free speech violations, though the basis of the chilling effect would be an establishment clause violation. Are there certain types of, say, Hanukkah-related expressions that are okay under the Establishment Clause to regulate, but the Bible isn't? Are there certain stories in the Bible, certain passages that are okay and certain ones that aren't? For school administrators that have to make those decisions on the ground, that in fact would provide an unworkable standard. The court has made very clear that the guarantee of neutrality that is
The
inherent
lemon
in-
test is easier?
I'm sorry?
The lemon test is easier?
No, that's
then-
exactly what I'm saying is more difficult, Your Honor. It's more difficult for school administrators to have to distinguish between different types of religious expression and remain within the bounds of the Establishment Clause. By contrast, this court's traditional approach toward viewpoint discrimination, well, it certainly isn't free from practical problems. It would be very difficult to come up with a perfect rule that was. But it has proven itself workable in saying, do not discriminate on the basis of viewpoint. Thank you.
Court is adjourned for the day.
All rise.
Mr. Piper and Mr. Frampton, will you please join us on stage? You may be seated. So the judges have retired backstage to figure out who the winner is going to be, and that might take a half hour. But we've got a couple of things to say to you, and then either the judges are going to come back on or you can converse among yourselves, okay? Look, there are people that work behind the scenes that make this stuff possible. And I just want to acknowledge them, and I hope you'll hold your applause till the end, but then I hope you'll applaud for them. In the dean's office, Marilyn Byrne, Nancy Donovan, Sarita Shepard, these people have been crucial to bringing this all together. Hold your applause. Susan Gluss in media relations has been crucial in this. And then for the students here, about half of you, this woman has served as den mother to you. Barbara Anderson has been crucial to bring this together. Please give them a round of applause. Now, oral argument is a portion of appellate advocacy, but before you deliver an oral argument, you write a brief. And in this case, every one of the McBaine competitors wrote a 25 to 40-page brief. Here to discuss the award for best briefs in the McBaine competition is the Director of Professional Skills, Professor David Oppenheimer.
Thank you. We are delighted that this year, for the first time, the award for Best Briefs has a name. It is, beginning this year, the Crowell and Mooring Best Brief Award, named after the international law firm of Crowell and Mooring, because of an endowment gift that partners and associates at the firm who are graduates of Berkeley Law have made for the purpose of underwriting and endowing the McBaine competition. I'm very happy to be able to introduce to you this evening the San Francisco lead partner, head of the San Francisco office of Crowell and Mooring. His name is Greg Call. He's a 1985 Boalt graduate. He organized the raising of this very substantial gift that we're so grateful for. And even though he was an undergraduate at Stanford, we've decided we'd still like to have him come up and say a few words and confer the award. Greg?
I want to first say what an incredible event, and congratulations to Boalt Hall. It's hard to imagine having advocated in many forums, advocating in any forum that is better than this one. I can't imagine that in every oral argument I've ever participated in, altogether, there's been as many people present who are present here. It is just an incredible, incredible event. Congratulations, Boalt Hall. Congratulations, BerkeleyLaw. It's just great. I want to say also how honored Crowell & Moring is to be associated with the McBaine competition. It is when you look at the past list of the winners, there's a Chief Justice of the California Supreme Court. There are Lions of the California Bar, such as Ralph Kennedy. There are friends of mine. There's one of my partners. And there are other people who are recognized as being leaders in the bar. Our sponsorship relates to the best brief. And while many of us like the lights and the cameras, just like in the Academy Awards, we root for the actors and the actresses, in many cases, it's the people who are working on the briefs and writing the briefs that win the hearts and minds of the judges and the justices. So it's a great honor for our law firm, who has many Boalt graduates. Actually, 1/3 of our San Francisco office is made up of Boalt graduates, to be able to make the award tonight. Having looked at some of the materials and some of my partners having judged some of the earlier rounds, can say that the advocacy, both written and oral, across the whole spectrum of Boalt students was incredible, and congratulations again for that. But there were two briefs that stood out. For the petitioner, Mika Zuckerman was the award winner. Congratulations. And for the respondent, Colin Hector was the award winner. So congratulations. Congratulations, and spectacular job, and congratulations to the first Crowell & Moring Best Brief Award winners. Thank you.
Thank you so much. We're going to take a short break until the judges are ready to return. We'll say all rise at that point, and you know what to do, right? Thank you.
All rise.
Please be seated. Thank you for coming up. I do moot courts because every once in a while I need an injection of hope. And I see performances like the two of you did today, and I have so much hope about our profession and its future. You were magnificent. It's hard, isn't it? Moot courts are not easy, especially when you're dealing with real judges. But for those of you in the audience who are lawyers or students And for those of you who are not, everybody thinks that, yeah, you should come in so well prepared that you should have a quick answer for everything the judges ask. It's not so easy, because we're us, and you can guess a lot about what we're going to ask about, but there's always a slight little twist, and it's not easy. It's nerve-wracking, it's scary, and I guess you figured out that preparation is what helps you get past that. But I am also very pleased with the skills the two of you showed. And it means that your law school, hey Dean, is doing pretty well in training. A moot court performance like you two gave today is never the product of just the two of you. It's the product of the advisors who worked with you, of your peers who mooted you before you came here, of all of the people who were involved in putting the competition together and helping you get to this place. And I thank all of those people for what they did. And I thank you for giving me a really enjoyable afternoon. For a justice to come and to listen to students do what you did today is really impressive. Now you have to understand that my court didn't grant cert in this case. And as I was reading nearly 150 pages of materials, I kept thinking, huh? Why did I agree to do this? But it was fun. Having said that, we're forced to make a choice. We're forced to make a choice because those are the rules. And since we are 3 justices, we follow the rules. We were in there a very long time because it was really, really tough to do. And so we picked a side, but there is no loser today. Both of you did extraordinary jobs. We've chosen the respondent as the winner of the competition, but say to the petitioner, you were only a thin slice below. Congratulations to both of you. Thank you. I thought they gave you something now, but obviously not. I think we now recess for the day. Thank you all.
All rise.
Court is now adjourned. Thank you so much for attending the James Patterson McBaine Moot Court competition. Good night.